Hello, everybody, and welcome. My name is Mitchell Zaddo. I'm the Managing Principal at Sharrock Pitman Legal, and thank you very much for joining us for our webinar today. First of all, I hope you're all doing well and have had a good start to the year so far, out of lockdowns, and hopefully you've dodged COVID too, or at least not been affected too badly. We started running these webinars, of course, during the pandemic, and we continue to offer them regularly on various legal topics, as we hope they'll continue to be a helpful resource to share with you some must-know information and guidance on different topics that might be of interest. Our previous webinars are focused on COVID-related topics, of course, employment law updates and starting a charity. If you missed any of those, you can catch up with the recordings and slides by heading to our website and clicking the link for our resources page. But today we're looking at the important area of wills and estate planning. This is a significant and growing area of our practice. It's always been a core part of our practice, of course, as lawyers, but it's an area that we find sometimes isn't understood in a lot of detail. There's a lot of information around, but it's often misunderstood, and we sometimes find that people miss opportunities to do their estate planning completely and effectively in their own particular circumstances. Sometimes a plain vanilla approach is okay, but it might not be optimal for your estate and, more importantly, for your beneficiaries. So it can be a complex area, but not one that's too difficult to get a good understanding of. So we hope to give you some good handles on the key things you need to know today. I'll shortly hand over to Binay Prasad, who will be taking us through today's content. Binay is a senior associate at Sharrock Pitman Legal and an accredited specialist in wills and estates. He has many years of experience in this area and really is an expert in the field. So I know he's looking forward to sharing his knowledge with you today. Firstly, though, just a couple of housekeeping things. We're obviously in webinar mode, so your cameras are not visible in the session, so don't worry. We are recording the session, and as I said, it will be available on our website shortly after today. If you do have any questions throughout the session, please type those into the Q&A box, and we'll try to get through all of the questions as we go along. We'll also have some time for more questions at the end. We are conscious of everybody's time, though, so if we aren't able to answer all of your questions before we wrap up, don't worry, we will get back to you afterwards, and we'll also share our contact details in the slides at the end, so you can get back in touch with me or Binay any time after today, of course. And before we begin, we are lawyers after all, so we do need to put up some fine print. Needless to say, we can only give you some general guidance in this session. Everyone's situation is different, particularly in this area, so that's really important to keep in mind when it comes to effective wills and estate planning. So just keep that in mind as we go through things today, and before doing anything, do make sure you get some specific advice, and again, feel free to contact either Binay or myself. So without further ado, I will hand over to Binay. Thank you, Binay.
Thanks, Mitchell, and good morning, everyone, and thank you for attending the webinar today. So as Mitchell mentioned, this webinar is really an introduction to the law of wills, and we'll go through some common legal situations that commonly arise when you're making a will. It's not going to be any really in-depth kind of legal analysis of wills. We go through a number of subheadings, and really each of those subheadings could be a whole webinar in themselves. But the purpose of today is just a general kind of introduction and to cover some common scenarios that might arise. So what we'll be going through is you'll be able to see on your screen there, what is a will, starting with the basics, what happens if you die without a will, what is the effect of marriage or divorce on a will, what assets are not covered by a will, what is a testamentary trust will, what challenges can be made against a will and how can you prevent a challenge. And then the last topic we'll be going through briefly is estate planning for blended families, and then we should have some time for some questions at the end. Thanks, Mitchell. All right, so what is a will? It's good to cover this, and it might sound like a bit of a basic kind of subject, but it's good to start with the basics. So a will is a binding legal document which sets out your wishes for the transfer of your assets on your death, and you can also nominate a guardian for your minor children in your will as well. will should appoint an executor. So an executor is a person who's legally responsible for your estate when you pass away, and the duties usually involve arranging your funeral, but obviously that can be organised in the family. It doesn't have to be the executor. Making an application to the Supreme Court for a grant of probate. So that's where the executor must apply for an order from the court before they're able to access the deceased person's assets. And then once probate's been granted, the executor's got the legal authority to collect all the deceased assets, pay any outstanding debts or tax liabilities, and then distribute the estate in accordance with the will. A will must be signed by the will maker in the presence of two independent witnesses. A beneficiary or a partner of a beneficiary should not be a witness to the will, because it can cause complications with the application for probate, because it raises a suspicion that that beneficiary might have influenced the will maker. So it's always advisable to have two independent witnesses who aren't mentioned in the will. Even if a will or a document does not meet those requirements where it's signed in the presence of two witnesses, it can still held to be valid. There have been cases where a video recording's been held to be a will, or a text message, or an unsigned document, but an application will have to be made to the court to approve of the will, and the court must be satisfied that the deceased will maker intended that document to be their will. So that's obviously quite an expensive process that the executor will have to go through. So obviously it's always best to make sure that you've got a legal and will in place which complies with the legislation. And finally, a will is not set in stone, unfortunately. It can be challenged, and we will discuss such challenges later in the webinar. All right, so what happens if you pass away without a will? Well, if you pass away without a will, the legal term is you've died intestate. The law sets out, in this situation, the law will set out who will inherit your estate. So we're not going to cover every single situation, just the most common situations which arise. So the deceased person left a partner and no children, or they left children only to that partner. And when I say partner, I'm meaning a married spouse or a de facto partner. Then the law says 100% goes to the surviving partner. If the deceased left a partner and children from another relationship, usually children from a previous relationship, well, then the law says that the first $486,870 will go to the partner. That's a statutory sum which increases each year. But that's the current amount as of this financial year. And then of whatever's remaining after that figure's paid, this partner gets a further 50%, and then the other 50% is divided equally between the children. If the deceased person only left children, there's no spouse or partner, then everything goes equally between the children. If the deceased did not leave a partner or children, then there's a hierarchy of who will inherit the estate, starting with parents of the deceased, then siblings, then nieces and nephews, etc., etc. It's also important to know that stepchildren aren't considered legal children of the deceased, so they don't inherit any of the deceased estate if there's no will. These set intestacy laws can also be challenged, which we will discuss later in the webinar. All right, so marriage, separation, and divorce. Obviously some very important life events, and whenever you have an important event in your life, it's always a good idea to review your will to make sure that the event doesn't have any effect on your will. So marriage, separation, and divorce are three situations which can or may have an effect on your will. Let's start with marriage. So if you marry, whether it's in Australia or overseas, provided that marriage is legally recognised, that will revoke, or generally it will revoke any will that you've previously made. So there are some exceptions. So if you have made a will and you left a gift to a person who is your married spouse at the date that you pass away, then that gift is still valid. Or if your will expresses or implies that it's made in contemplation of marriage, then the will won't be revoked. But there's always, obviously that does create uncertainties and can create difficulties. So if you do get married, it's always a good idea to review your will and get some legal advice as to whether your will has been revoked. And if so, obviously you should update your will. It's also important to note that this only applies to marriages, not de facto relationships. So if you enter into a de facto relationship that has no legal effect on your will. Now moving on to separation. Separation in itself does not revoke your will. So if you're with someone, whether it's de facto partner or you're married to someone and you separate, that won't revoke your will. So it's always advisable to review your will at that point. And if you don't want your ex-partner to inherit, you need to update your will. And then of divorce, which only applies to legal marriages. If you legally divorce, then the divorce also does not revoke your will, but any gift that you've made to your ex-spouse will be revoked. This won't apply to de facto couples either. So if you're in a de facto couple and you separate, your will remain in place, and any gift that you've made to a previous partner will still be effective unless you update your will. I find it's always good to provide an example to kind of explain what we've just gone through. And this is actually a real life case that we're currently dealing with, a client by the name of Sarah. So her situation is that her father had quite a substantial estate in Australia, and he made a will leaving his estate equally between his two children, Sarah and her brother. Then the father actually moved to the Philippines to pursue some business opportunities, and he met a Filipino woman over there, and actually they got married in the Philippines. So unbeknownst to the father, that actually revoked the will that he'd previously made in Australia. A few years later, the father passes away in the Philippines, and because his will's been revoked, he's treated as dying without a will, which means that the new wife inherits most of the estate. It might have been the intention that the father did want his wife to receive some of his estate, but now, unfortunately, there's a big dispute between the children and the spouse as to how much the wife should get and how much the children should get. So that situation, it's quite an unfortunate situation, and it could have been avoided if the father had made a new will after he had married in the Philippines. All right, so this is important. Many people think that all of your assets will be covered by a will. That's not the case. There are many types of assets that won't be covered by your will. So we're going to go through the main types of assets that are not covered by your will, and it's important to get legal advice to make sure that these assets that aren't covered by your will, you can still pass control of them after you've passed away. So the first one is jointly owned property. If you jointly own property with another person, which is most commonly a property, a house or a bank account, on the death of one owner, the surviving owner automatically inherits 100% of that property. So it doesn't matter if you've written a will giving your share in the property to someone else, that won't be effective. The surviving owner just gets 100% of the property. There is an exception. So if you, and this mainly applies to real estate. So if you own the property as what's called tenants in common, and that should be registered on the title that you own the property as tenants in common. That means you each own a separate share in the property, and you can gift your separate share in the will. But the default position is usually that you're what's called joint proprietors. If you're joint proprietors, when one of you passes away, the other owner will automatically get 100% of the property. Superannuation is another important asset to discuss, given that most Australians, I'd say, would have some superannuation. So superannuation isn't automatically covered by your will. You generally can't gift superannuation in your will. What you need to do is you need to make what's called a binding death benefit nomination, or BDBN, they're commonly called for short. You need to make a BDBN with your super fund. So that's a document where you state who you want your superannuation to be paid to on your death, and it needs to be signed before two witnesses, but it's actually separate from your will, and it needs to comply with the rules of the super fund. Usually your super fund will provide you with the form that you need to complete in order to make a BDBN. You can't just nominate any person. The law says you can only nominate certain people to receive your superannuation, who are your dependents, being a partner or a spouse, children, stepchildren. Sometimes it would depend on the super fund rules, or a financial dependent or interdependent. Or you can also nominate your estate. So you can nominate that on your death, your super is paid to your estate. If you nominate your estate, then your super actually will be covered by your will, because your will covers any assets that form part of your estate. So if you're intending to gift your super to someone who's not a dependent, it's always advisable to make a binding nomination that your super is paid to your estate. And then in your will, you'll direct who you want your super to be paid to. If you don't make a binding death benefit nomination, then the super fund will decide who to pay your super to, which might not be in accordance with your wishes. And then also, if any of you have a self-managed super fund, you should also always make a binding death benefit nomination. The same rules apply. But it's also important to take steps to ensure that control of the self-managed super fund is passed effectively on your death in accordance with your wishes. So, quite often that there's a trustee of the self-managed super fund. It would be a person or a company. You just need to take steps to ensure that the the person who has control of the trustee after your death is who you want. A solicitor can help you with that. Family trusts are quite common these days. If you own investments through a family trust, such as investment property, you cannot gift that investment property in your will because it's not your asset, it's the trust asset. So what you need to do is take steps to make sure that control of the trust is passed effectively on your death. So a family trust will have a trustee. You just got to make sure that on your death, you've got some control over who the trustee is going to be, who's going to manage the trust once you pass away. And the same goes with companies. If you own assets through a company, such as cars, you can't say that this company car goes to this specific person in your will. All you can do is gift the shares in the company in your will, so that in a way passes control of the company on your death, but you can't gift specific assets in the company in your will because they're not your assets, they're the company's assets. All right, now we're moving on to foreign assets, becoming more and more common for people in Australia to own assets overseas. So does an Australian will cover assets in other countries? Well, the answer is it's complicated. It will depend on the individual laws of the country where the assets are located. And obviously every country has got different laws, and for countries such as the United States of America, every state in the US has different laws. So it can be quite confusing. So what we generally advise to avoid any uncertainty is that you do separate wills. So you have a will which only applies to your Australian assets, and when you pass away, it will cover your assets in Australia, and then you make a separate will in the country in which you hold other assets, which will comply with the laws of that country. So when you pass away, that foreign will appoint an executor, and then that executor would use that will to gain control of your foreign assets and distribute them in accordance with the will. That's usually the simplest way to avoid any confusion and difficulties with the conflicting laws of different countries. Thanks, Mitchell. All right, testamentary trust wills. These are becoming quite popular. They're basically, well, they've got a number of benefits, which we'll go through. With testamentary trust wills, like I said, there's a number of advantages in doing a testamentary trust will. There are really no disadvantages because usually the trust set up in the will are optional. So the only thing is it might cost a bit more to draft them at the start because they do, they're more complex documents. But apart from that, there really is no disadvantage in doing a testamentary trust will, even if you think that they might not be used. So there are a few different types of testamentary trust wills. We'll go through the two main ones. So the first one, which is probably the most common, is I guess you can call it an optional testamentary discretionary trust. So what this means is that in your will, you'll give each beneficiary the option of receiving their inheritance through a discretionary trust, which the beneficiary will control. So what that means is that the beneficiary can choose just to receive their inheritance directly to them if they think that's the most, financially effective way to do it, or they can decide to receive their inheritance through that trust which you've established in your will. And then the benefit of that is, well, there are a few benefits, or quite a few benefits. Firstly, the inheritance can be invested through that trust, and any income earned on that trust can be split between multiple beneficiaries, which will just reduce the overall tax bill. I mean, those of you who operate family trusts will know that family trusts operate in a similar way, where any investments held through the trust, the income can be streamed to different beneficiaries and reduce tax. Same goes with testamentary trust in a will. The other advantages of having testamentary trust in your will is that it can give some protection to a beneficiary from creditors or from bankruptcy. So if you've got a beneficiary who might be suffering some financial difficulty or perhaps even going through bankruptcy, if they can put their inheritance in that testamentary trust, then it's going to be protected from any claims from their creditors or from the trustee in bankruptcy. And then another benefit is if the beneficiary of your will is going through family law or separation, then if they're receiving their inheritance through that trust, then to an extent, the inheritance can be protected from a family law claim from the partner that they're separating from. Now, that does get a bit complicated with family law claims, which I'm not going to go into detail in this seminar, but if anyone needs some further advice on that, by all means, feel free to get in contact with me. Now, the other type of kind of testamentary trust, which is often used, is what's called the protective trust. So that's used in circumstances where a beneficiary may not spend their inheritance wisely. For example, they might have drug or gambling problems. So the way the will works is the beneficiary's inheritance, rather than the will directing that the beneficiary receives their inheritance directly, the inheritance will be held in a trust for that beneficiary. It'll be quite a restrictive trust. The trustee will be a third party, for example, a family member, and then the trustee will control the trust and can distribute funds to the beneficiary as needed, but the beneficiary won't have access to the funds themselves, so they won't be able to spend the funds unwisely. With these types of protective trusts, it is always helpful to, if you're thinking about setting one up for a particular beneficiary, such as a child, it's always helpful to discuss what you intend to do when you're making your will, because the last thing you want is for the child to not be aware that you've made this protective trust for them, and then they find out after you've passed away. And then there are circumstances where they can actually challenge the protective trust, which could be avoided if it's all discussed beforehand so that everyone's in agreement. Now, I guess testamentary trust can be a bit hard to get your head around. So what I've done here, I've just come up with a kind of a fictional example just to hopefully better explain the benefits of testamentary trusts in your will. So we've got a couple called Ravi and Meena. They've got assets worth $3 million. They've got two daughters, Patricia and Doreen. Patricia's a doctor, so she's on a high income. Doreen, unfortunately, has had substance abuse problems in the past. So after both Ravi and Meena have died, their wills direct that their estates split equally between Patricia and Doreen. So for Patricia's share, the wills state that she's got the option of receiving her share through a discretionary testamentary trust. Patricia decides to take advantage of this trust and she receives her $1.5 million through the trust and uses it to purchase an investment property with a net rental income of $25,000 a year. So rather than receiving the rent from the investment property herself, which would be taxed at 45% due to Patricia's high income, Patricia applies the rent for the benefit of her two children, who are also beneficiaries of the trust, and are both still in school and not working. So each child has the benefit of the tax-free threshold, which is currently $18,200, which effectively means that no tax is paid on the rent received from the property. So you can really see the advantages, the tax advantages that testamentary trust can provide, because if the will just said everything went directly to Patricia, and then she used those funds to purchase an investment, then she'd be taxed at a really high rate on the income because of her high income as a doctor. Now, moving on to Doreen. So what Ravi and Meena decided to do for Doreen's half is to put it into a protective trust. So it's a mandatory trust. Doreen doesn't have the option of receiving it directly. It has to go through the trust, and the trustee is Patricia. The beneficiaries of the trust are Doreen and her children. Patricia as a trustee can apply trusts from the fund for Doreen and the children's accommodation, education, living expenses, etc. But Doreen cannot access the funds herself, which will protect the funds in case she suffers a relapse into drug abuse. All right, now moving on to what challenges can be made against a will. There are a number of different challenges. We're going to go through the most common types. So the most common type of challenge by far against a will is what's called a family provision claim. It's got some other names that it goes by. It's also called a Part 4 claim, or sometimes a testator's family maintenance claim. So this is a claim where, this is a situation where a person's been excluded from a will or given very little in a will, and they're not happy with that, and they make a claim against the estate for further provision. So not anyone can just make this kind of claim. That used to be the case, but the laws got tightened up about 7 years ago or so. So now only certain categories of people can make such a claim. So those include a spouse, partner, child, a stepchild. There are a number of other categories which aren't used that often. Grandchildren are also eligible to make a claim, but they do have to show that they were financially dependent on the deceased to be successful. So just because someone's eligible to make a claim against the estate doesn't mean that they're going to be successful. The court will assess a range of factors, including whether the deceased had a moral duty to provide for the claimant. So generally it's established law that a deceased has a strong moral duty to provide for their spouse or partner or for minor children. When you're talking about adult children or stepchildren or even remoter kind of relatives like grandchildren, I guess the moral duty becomes weaker and weaker and weaker, and the court will assess the level of duty that the testator or the will maker had to the claimant. The other factors, the other main factors the court will assess are the relationship between the claimant and the deceased. So if the claimant didn't have a particularly good relationship with the deceased, quite often is with children, is the case with children, that perhaps an adult child was estranged from the deceased, didn't make any efforts to really have a good relationship with the deceased, well, that can be taken into account and it can work against them in assessing the claim. And finally, a very important factor that is also considered is the financial position of the claimant and whether they're actually in need of provision from the estate. So generally, the more financially well off the claimant is and the more able they are to provide for themselves from their own assets and income, the less likely that they're going to be successful in making a claim against the estate for further provision. What steps can you take to prevent a family provision claim against your will? There are a few different methods. One is you can make a written statement expressing your reasons for excluding a person from your will. This isn't going to eliminate a challenge. The person can still make a challenge even though you've provided this written statement, but the court will take your written statement into account and it can be used to weaken the claimant's claim. A more drastic measure you can take to prevent a family law claim is to actually move assets out of your estate. Because when you die, the claimant can only make a claim against their assets that are in your estate. So if prior to your death you've taken steps to divest your estate of assets, then there might be very little in the estate to actually make a claim against. So you can do things such as gifting your assets prior to your death to your intended beneficiaries, so that once you've died, they don't form part of your estate. You can make a beneficiary a joint owner of your property so that when you pass away, the property automatically goes to that beneficiary and won't form part of your estate. Or you can take other steps such as moving assets into superannuation or family trusts, which will also remove assets from your estate and won't be able to be challenged after you've passed away. But the very important thing is if you're considering of restructuring your assets, it's really important to get proper legal and financial advice before you do that, because particularly in relation to real estate, if you take steps like gifting real estate to people before you pass away or moving real estate into family trusts, there will be stamp duty consequences. There can also be capital gains tax consequences. And if you're receiving a Centrelink pension, or you might receive the pension in the near future, if you're gifting assets, then that might reduce the amount of pension that you can receive. So make sure you get financial advice before you take any steps to move assets out of your estate. Another common challenge that's made against the will is that the will maker lacked mental capacity when they made the will. The person making the allegations will need to provide medical evidence to prove their allegations, which can be difficult. Nevertheless, if you want to prevent any kind of suggestion or allegation that you've lacked mental capacity when you made a will, then it's always advisable to get a medical assessment of your capacity at the time the will is made. So provided obviously the medical assessment says that you do have capacity, then the report can be produced after you passed away to defend any allegation that you lacked capacity, and that will be very effective. Finally, another common allegation that's made after a person has passed away is that a beneficiary unduly influenced the will maker to make a will to benefit that beneficiary. So the person making those allegations will need to provide evidence of that undue influence. That can be difficult. A very high standard of proof is required by the court, given the seriousness of the allegations. Nevertheless, if you want to avoid any kind of such allegation being made after you've passed away, there are steps you can take. It's advisable that you have your will drafted by an experienced solicitor who will know what to do. They will see you alone, they'll satisfy themselves that there's no undue influence, and they'll make a detailed file note confirming that. And then after you've passed away, if someone's alleging that you as the will maker were unduly influenced into making your will, then the solicitor's evidence can be produced to defend that allegation. All right, the final topic we're going to cover today is estate planning for blended families. So obviously blended families are becoming much more common these days. So, the common scenario is you've got a couple, they met later in life and both have adult children from previous relationships. So the dilemma is when one of the partner dies, how do they properly look after their surviving partner whilst also ensuring that their children will also benefit from their assets? So there are a few different strategies that can be adopted. One is to do what's called mirror wills, which you don't actually recommend, but I'll explain why in a minute. But firstly, so mirror wills are when each of you do fairly simple wills saying that when one partner dies, everything goes to the surviving partner. And then when both partners dies, whatever assets are left are just split equally between the children from both sides. The reason we don't recommend this is because it does involve a lot of trust. So because each partner's done a will to this effect, then one partner dies, there's nothing stopping the surviving partner from changing their will to cut out the children of the deceased partner, or they can take steps to move assets out of their estate before they pass away, which means there would be nothing left in their estate or very little when they do pass away. If you both trust each other, that's great. Quite often our clients do instruct us that we know the risks, but we trust each other and we're just going to stay with the mirror wills. But as solicitors, we usually advise that you have some further protections in place. So some other strategies you can put in place are what are called mutual wills. They're not so common these days, but basically what a mutual will is that you do mirror wills as I've just outlined, but also each partner will enter into a separate contract where they both agree not to change their will nor deplete their estate after the death of the first partner. They are very effective. It's a contract and it will be binding, and the surviving partner will be held to that contract. But the disadvantage is they can be quite inflexible. There might be good reasons why a partner, the surviving partner needs to deplete the estate. Maybe they need to sell the family home to fund their aged care, but they're prevented from doing so because they've entered into this contract. Or there might be other situations such as the surviving partner, after the death of the first partner, the surviving partner comes into an inheritance, which, you'd expect they shouldn't have, the children of the first partner shouldn't benefit from the second partner's inheritance, but then they've locked themselves into these mutual wills saying everything's 50-50 between the children from either side. So there are some risks involved in doing mutual wills, but they can be overcome if the contract and the wills are very carefully drafted. And finally, perhaps a more common strategy you can put in place to protect any disputes down the track is to change the ownership of your property. I'm particularly talking about real estate here. So as we went through earlier, you can own real estate either as joint proprietors or tenants in common. So what we'd usually advise is to change the ownership of your real estate to tenants in common, and then each partner can control in their will what's to happen with their share when they pass away. For a family home, would usually recommend that the will, in addition to, allows the surviving partner a right to continue living in the family home, which will mean that they're not going to have the house sold from underneath them. And then the survivor also has the right to sell the property and use the whole proceeds to fund, aged care or a retirement village or something like that, provided the first partner's share of the proceeds is preserved for their children. And then when both partners have died, each sets of children, because the partners have really split their assets, there's nothing jointly owned. Each set of children will each receive their share from their parents' estate. So that pretty much covers the basics with wills and kind of common situations and legal implications that can arise. So we do have some time for questions. So yeah, feel free to send them through and I'll do my best to answer them.
Yeah, thank you very much, Benay. We don't have any questions pending just yet, so everyone, if you feel free to pop one into the Q&A box if you'd like to. I guess one of the key things with all of this, as you can probably tell, is that there's a lot of options, and it very much depends on the circumstances, the family situation, asset situation, and there's a lot of things that can be done to really tailor the estate planning to suit your situation and make sure it's going to work most effectively and most importantly work best for your beneficiaries. We have a question: if parties in a second marriage have a binding agreement, I think that's a reference to a binding financial agreement, does that need to be referred to in the will so that it can be abided by? Benay?
I assume what you're talking about is a binding financial agreement, which will cover doesn't cover what happens when you pass away. It's more if you separated, and then the binding agreement will set out how the assets are divided, so there's no family law disputes. It usually wouldn't be referred to in your will. No, but the binding agreement yourself, quite often. I mean, I'm not a family lawyer. I do have some family law experience, but my understanding is, but the binding financial agreement that you have with your partner will often have some clauses to cover what would happen when you do pass away. So they usually have a standard clause that when one partner passes, if one partner passes away, then the other surviving partner is prohibited from making any challenges against their estate.
Next question: I'm a company director and my wife owns the house. What sort of trust should we have? Should we have a testamentary trust?
It gets complicated. I mean, when you say you're a company director, it depends, what kind of assets are owned through the trust. A testamentary trust might benefit you. It really would depend on the amount of assets that are owned in your personal names, because the testamentary trust in your will only covers assets that are in your personal name. It doesn't cover assets that are held through the company. So it might benefit you, but you need to get specific advice about your particular situation.
We have had clients before who've been in that situation, and there's a prospect of them inheriting the house if their wife or the other spouse who holds the house passes away. So it can be good to have that option. But there are when it comes to your residence in particular, there are some other things you'd weigh up at the time. Obviously, if you have a principal place of residence, it's usually exempt from land tax and capital gains tax when you sell it. But if you hold it in a trust, you lose those exemptions because a trust does not have a principal place of residence. So some people find that that's perfectly fine. That's just a necessary cost of the protection of having it in a trust. So it's a matter of getting that advice and seeing what all those things would involve at the time, and then you can make a decision. But certainly if you've got testamentary trusts in the will and it's optional, then you've at least got that ability to put certain assets into a trust if you'd like to at the time. Next question: will the beneficiaries of the estate be taxed with inheritance tax?
The answer is no. If the assets are in Australia, we don't have an inheritance tax in Australia. The only exception is for superannuation. So if superannuation is paid to what's called a non-tax dependent, so which is, probably easy to explain what a tax dependent. So a tax dependent is a spouse or partner or minor children. So if superannuation is paid to anyone else, so quite commonly adult children, then it will be taxed. I'm not an accountant, but I believe that the rate's between 15 to 30%, depending on a number of different factors. So in short answer, there's no inheritance tax in Australia, but superannuation can be taxed if it's paid to a non-dependent.
the main tax that comes up in estates is capital gains tax. So that can be a bit of an indirect tax on the estate. So if the estate, if the will maker, the deceased person, had an investment property or shares or something like that, that the executors then sell as part of the estate, there will be capital gains tax to pay on those. So that indirectly will impact on the amount that flows through to the beneficiaries. But yeah, Benay is correct. There's no inheritance tax per se.
Yeah, that's right. There's no separate inheritance tax, but just ordinary tax principles regarding capital gains tax and income tax will apply still. So.
Yeah. We've got a few questions coming through, so we'll try to get to everybody if we can. With blended families, how would you handle large discrepancies in what each partner has brought into the relationship?
Yeah, well, that would require very careful drafting of your will. And obviously everyone, the two parties or the two partners would need to have a really frank discussion between them as to how they'd want their respective assets to be distributed after they pass away. If you own property jointly, that might not be an ideal way to hold property because, as we mentioned earlier, when one of you passes away, the surviving partner automatically gets 100% of the property. So it might be advisable to split, I'm talking about mainly real estate here, to split it to tenants in common. You don't have to be 50-50 owners for tenants in common. You can do a 25-75 split or however, whatever proportions you decide. But that might be a mechanism you can use to make sure that whichever party's brought in most of the assets, they have a greater share in the property, which they can direct in their will compared to the other partner. And you can also do things like make not binding nominations for your superannuation as well to try and even things up. But it can be a very difficult exercise. But yeah, you just got to look at everything very carefully and see a good lawyer.
And Benay, how long does a binding nomination for superannuation last for? How long is it valid for?
Yeah, look, that's a tricky one. It used to be pretty standard that it was 3 years. So it and that's in the legislation. So it would have to be updated after each 3 years, which is so it's important to check that with your super fund and know when it's going to lapse. And this is getting a bit off topic too, but it's also important to have a power of attorney in place so that the binding nomination can still continue to be renewed when you've perhaps you're still alive, but you've lost the capacity to do that yourself. But what we're seeing more and more now these days is what's called a non-lapsing nomination. So that's a binding nomination that you just make once and it doesn't actually lapse. Now, there's actually a bit of uncertainty about those, and I believe there's actually a High Court challenge currently underway in relation to non-lapsing nominations. So yeah, sorry, in answer to your question, the general position is that a nomination will last for 3 years, and you should also always check with your super fund to check when your nomination actually lapses.
Yeah, if your super is with a retail fund or an industry fund, when they send you your statements, it should say on there whether you have a nominated beneficiary. So check that, but keep in mind that even if that's still current when they send you the statement, it could expire or lapse in the between statements. So just keep an eye on it. Another superannuation related question, Benay, what if you both have a binding death benefit nomination for your super to each other as spouses, but both die at the same time? Does the superannuation become part of their estate for their children?
Look, I mean, it depends. Like some super funds will allow you to nominate a secondary beneficiary. So you'd nominate your spouse in the first instance, but if they've already passed away, then it would go to another nominated beneficiary, such as your children. Like not all super funds will allow that. So if you're with a super fund that doesn't allow that, which just says you can only nominate one person and there's no backup nomination, then you really what's happened is that your nomination that you've made to your spouse is not effective because they've passed away, and then the super fund will actually have discretion as to who to pay the super to. They can't just pay to anyone. They can only pay to dependent, which would usually be children or your estate. And generally, they would preference paying it directly to children. They'd usually only pay it to the estate as a last resort. But there would be a bit of uncertainty there.
And how long is the vesting date for a testamentary trust? Is it 99 years? Can it be extended automatically?
All right, so it's not quite 99 years. The maximum length of the trust according to law is 80 years from the date of creation. So the trust is actually created on the death of the deceased. It's not created when the will's made. So it's 80 years from the death of the deceased. But, most standard testamentary trust wills, and our wills certainly have this clause, is that they give the trustee the power to vest the trust at any time that they think appropriate, provided it's not longer than 80 years, because the law does not, in Victoria at least, the law does not allow you to have a trust for longer than 80 years. And and it can't be extended after 80 years either. So.
It can be wound up earlier than that if the trustee and the beneficiary want to do that. So if your beneficiary wants to use their testamentary trust, they're not having to lock that in for themselves and their children and their grandchildren over the next 80 years. It can be brought forward, but as Benet said, definitely cannot be extended. Just a quick one. Somebody's asked if this will be available to rewatch. Yes, we will. We are recording it, so it'll be on our website soon, and we can certainly send a link around to everybody. But we'll try to get through the last few questions. If you've got any more questions, we may not be able to get through them, so feel free to get in touch, but we should be able to get through the ones that have come through already. There's a question about somebody having an estranged adult child and leaving. That this is something that does come up quite frequently. If you leave them, say, $50,000 in your will and with an explanation as to why you don't want them to benefit further, can they still contest the will? If so, how can you avoid them contesting? Is there a limit of funds you need to leave them? We do get that question a lot, don't we, Benet?
Yeah, that's right. So the short answer is they can still, unfortunately, yes, they can still contest your will. The fact that you've made a statement explaining your reasons why you don't think they're entitled more will be very helpful and can be taken into account. But ultimately, it will depend on a number of factors, such as the size of your estate, the financial position of that child, and also what kind of relationship that child had with you or lack thereof. So, it won't it won't completely rule out a challenge if you just do that. And there is no real amount that you can give a child to prevent a challenge. I mean, obviously, the more you give them, the less likely they're going to be able to convince a court that they're in need of further provision, but there's no actual amount. It will just, like I said, it depends on a range of factors, and there is always a bit of uncertainty there. So, sorry, you go.
Giving them something at least shows that you've considered them. Yeah, it's not you haven't accidentally left them out, but there's other ways we can deal with that as well. So,
yeah, as we went through before, there are other options you have, such as trying to limit the assets that form part of your estate when you pass away, and that's also a very effective way of preventing a challenge.
And if there is a dispute over the will, Benet, is it correct the legal costs come out of the estate?
Not always. So particularly, I mean, that used to be the position once where it was kind of the default position that all costs would just be paid out of the estate. But the courts are becoming a bit stricter in recent years, particularly if a claimant takes their matter all the way before a judge and loses. It's quite often that the claimant will be ordered to pay their own costs and might also be ordered to pay the costs of the estate. So it's definitely not automatic that just the estate pays for everything. But in practice, what usually happens is very few of these kind of claims will end up before a judge. They usually go to mediation first. Well, they will always go to mediation first because mediation is mandatory. And usually a resolution will be reached at mediation, and the standard agreement is that the estate will pay the costs. But yeah, if it goes before a judge, definitely it's not automatic that the estate will pay everyone's costs.
And as part of the mediation, everyone is required to disclose their costs to that point, and that kind of stuff. So everything's known, and that can all be accounted for and taken into account when formulating some kind of settlement that everybody can live with. So my dad is an overseas person but owns an apartment here in Melbourne. Does he have to create a will here? And what happens if he doesn't? Could I, as the only son, make a claim of it with my mother's agreement?
Look, it's recommended that he makes the will here, just to avoid any uncertainty. If he doesn't make a will here, well, then it will really depend on the country that the laws of the country that he was a resident of at the time, and also the laws of Australia. So It gets complicated. It would depend if he's living in a country which recognises Australian grants of probate. So they're usually ex-British colonies such as Singapore, Malaysia, Hong Kong, Canada. Those kind of countries, it might be easier for the Australian property to be just distributed according to the will that he's made in the country that he's living in. If he's in another country, well, then it does get complicated. It really will depend on the laws of the country that he's in. But you can contact us for more specific advice if you need it.
And if the second part of the question, if you were able to make a claim as the son, if your mum agreed, you could. It would depend how that's done. Would depend on whether there is a will or not, whether your mum is actually a beneficiary under the will or through intestacy if there's no will. So there's a few factors that might come into play. That there could be some way of reaching agreement on what to do with the apartment, and there is something which we haven't touched on today. There is possible for executors and beneficiaries of a will to form an agreement to do something different to what the will says. There's some rules and regulations about how that is done. That is something that we do from time to time. Down to the last couple of questions now. Thank you, everybody. These are really good. We have joint properties owned with my brother's super fund and our super fund, or the company trust that owns them. One title says tenants in common and the other says joint proprietors. What happens if any of the four of us dies?
Well, we'll probably need to review the documents to give you a proper answer, but when you say the title says tenants in common or the other one says joint proprietors, that might be not actually you that owns them. It might be the different super funds which own them. So that the trustee of the super fund might be registered on the title. So when a member of the super fund dies, what's registered on the title of the properties wouldn't necessarily matter. That the rules of the super fund will direct how the benefit of the deceased member is paid. So I wouldn't necessarily be alarmed that if that's the situation, that the titles say different things. But we can definitely review all of that if you'd like.
Yeah, you can feel free, if you have copies of the title, feel free to contact Bidet afterwards, and we don't mind having a quick look for you. Or if you have lost track of the title, we certainly can do title searches with Land Registry to see what's up to date. Penultimate question, Bidet, why would you, when you retire, should you withdraw your super and redeposit it to avoid tax for children of the state if you die?
Look, I mean, that's really something you'd need to speak to a financial advisor about. My understanding, it is quite a common strategy to avoid the tax on your super, because if you withdraw it before you pass away and then in your will you just leave it to your children, then there shouldn't be tax payable on that. But make sure you get proper financial advice before you start making withdrawals from your super to make sure that there aren't any other negative financial consequences of doing so.
Yeah. And final question, my wife and I did wills over 10 years ago, but we cannot find the documents or remember the name of the solicitor. Do wills get filed somewhere so that we can ask for copies? That's a good question.
The answer is generally no. I mean, the Supreme Court does have a register of wills where you can deposit your will, but hardly anyone deposits their will or registers their will with the Supreme Court. So you can check with the Supreme Court, but chances are the will was never registered with them. So if you don't know which solicitor, who did your will or where the wills are or which solicitor held your will, it might be very difficult for you to find where your wills are, and it's probably advisable to make new wills so that, and which will revoke the previous wills, and then you'll know where your wills are. It's very important to have the original will with you, because when you pass away, the executor of your estate will need the original to submit to the court to get probate. It can create a lot of difficulties for them if the original will can't be found.
Sometimes we do find that wills do go missing, or the executor thinks, we've got this will, but I think mum made another will with another lawyer, but we can't remember where. As lawyers, we can put notices in our Law Institute journal and things like that, but you're kind of just fishing to see if another law firm sees it and might recognise the name and have a will in their office, and also will delay the administration of the estate as well. So yeah, I think if the wills are lost and you're not sure where they are, the best thing would be to do some new ones. And to know that, make sure that the executors you're appointing in the new ones know that you've made these new ones, just in case someone does happen to come across the old ones. You don't want them thinking that they are the wills and not being aware of the new ones that you've done. So thank you very much for all those questions, everybody. There's some good ones in there, and as you can see, it's a deceptively simple area and a lot to it. So we do have some more resources if you'd like to read a bit more about this stuff on our website. Our lawyers in the Wills and Estate team are always writing new updates about things that are happening and guidance on various things. So if you want to dig a bit deeper into things like special disability trusts and preventing challenges, head to our website. The Supreme Court has some useful sort of overview guidance on wills and also probate and administration of estates. That's something we can talk about in a future webinar as well. And we've also got some guides on our website you can download about probate and estates, and there's a guide to estate planning after separation. It does have some general guidance in there about wills and powers of attorney and super. So you may find that useful as well, even if it's not in the context of a separation. And we do have hard copies of those too. So if you would like hard copies, just get in touch and we're happy to send those out to you. Just a quick couple of plugs before we wrap up, if you'll forgive me. If you're interested in looking at how a systems approach can help drive excellence and high performance in your business or organisation, a reminder about David Sharrock's book, Fighting for Enterprise Success Through the Eye of the Tiger. It contains lots of wisdom, guidance and reflection from David. Those of you who know David over the years would know that he's a fond of lots of wisdom there, and also includes lots of assessment tools and templates and samples from our business that we put out there in case they might be useful to adapt and take bits and pieces away from. So check that out on the website if you would like to, if that's of interest. And our next event is going to be our quarterly School of Hard Knocks for stressed business people and reluctant entrepreneurs. Our first one for the year on March 22nd. It will be by Zoom, and our special guest will be Paul Wade, perhaps best known for his career as captain of the Socceroos in the late 80s and early 90s, and now shares his knowledge with the business world as a keynote speaker, coach and facilitator, and he does a lot of work with Melbourne Business School. So Paul will be speaking on the topic, the first day of the rest of your life, leading by example and succeeding through adversity. And I'm sure there's probably something in there we can all relate to after the last couple of years that we've had. So do save the date, Tuesday, 22nd of March, and we'll send more details about that around in coming days. So that brings us to the end of today's event. Thank you very much for joining us. Thank you, Benet, for sharing your knowledge. And as we said before, if you do have any queries on anything that we haven't been able to cover today, please don't hesitate to contact us and we'll be happy to have a chat with you. In the meantime, we wish you all the best and have a nice day.
Thank you.